Welcome to Rich House Crime. We got more entitled content. Entitled Squatter Scam Backfires. Judge demands to see her partner, then reality hits hard. I need to know where you're from. All right? Don't be bougie in the comments. That's the only way we're going to be able to connect. Let me know where you're located and let me know your view on this case. And let's get right into it.
This is Andrew Elliott.
And we have yet to get in contact with Mr. Elliott. He's the named person on our
He's
lease.
not here. He needs to be here.
Understood. I've been messaging with my partner.
Jarrett Lepic versus Andrew Elliott.
Today's case is the final hearing in a 5-month rent-free saga where Taverzia has been squatting without paying a dime. But this time, the landlord pulled a fast one, shifting the case onto her mysteriously absent partner. The one who's actually on the lease but has never...
Can I get a PP in the comments for pet peeve? A pet peeve of mine are for people that don't work hard for what they got. They just steal.
...shown up to court. Now, with $15,000 on the line, the big question is, does he even know he's about to take the fall? Or does he actually show up and argue his case?
They had purchased a home, and the house sale fell through 2 days before we decided, or before we went into closing, and they had asked to move in. We said, if you pay the mortgage, we drew up a lease based off of them purchasing the home, and this is where we're at. So what happened is then they just stopped paying, and now
how much do they owe in rent?
So it was a $5,000 for 4 months. So
Wow.
that would be a total of $20,000. And we also missed out on listing the home again because they have refused to not leave.
We've gotten screenshots of proof of funds. We've also been told that ACH has been sent. We received a tracking number at one point that actually never registered with the U.S. Postal Service.
Wow.
And so there's been a lot of like, we're going to pay, and we haven't yet to receive anything.
We're leaving. We'll be out by the 1st.
I'm going to expect that if you have not surrendered the keys, that you will be in court and in a position to surrender keys to the Lepics at that point.
Okay.
Then we'll look at what money's there, because then that doesn't run, and we'll figure out.
If you don't got money for your bills, don't get the spot.
I will say we're moving to Seattle, Washington. I will make plans to appear in court in person, but depending on what our living situation is, then it might complicate my ability to show in person. Is there any recourse?
And you need to get them the keys.
Oh, I can easily get them the keys regardless.
Okay.
See, she tried to play.
They need the keys.
It'll be before the court.
Last week, sir, you had asked that they be out of the house before the hearing today. And as of right now, they're still moving stuff out of the property. There are still people on property.
Conveniently at a moving facility.
Including a couple of unauthorized additional roommates that weren't included in the lease. And we have yet to get in contact with Mr. Elliott. He is the named person on our lease. So we would just like to see what his status is. We haven't heard from him since the 7th.
Ma'am, are you moving out?
Yes, we've returned the key. I have a couple of friends currently helping me move out the remaining things. I'm actually at the U-Haul Center right now, and they are getting the rest of the items out presently under the supervision of the land manager.
Your stuff
You're
is
already
still
out.
Right.
Your stuff,
And they have surrendered the keys?
Yes, and it's in the process of being removed as we speak. So we are out. It'll be another hour or two, I think, before it's all of our stuff is gone.
So then the only issue is what's owed.
Right. I also want to bring up, if I may, Your Honor, we were subjected to a wrongful lockout, so we are due 3 times damages of the $150 for a locksmith as outlined in Michigan's anti-lockout statute, totaling $450, which I also have evidence of.
Out of 20,000?
Okay.
they were pocketing the rent that their roommates paid. They've just been sitting in my house, sir.
This is incorrect.
Okay. All right. Possession is not.
Sorry.
Pardon?
There are still people at the house. One of them is had a residence established there apparently.
I might as well, because the parties don't seem to agree, set this matter for trial. So non-jury trial in this matter then will be set for February 18th, 2025, 9 a.m. Okay.
And understood. And Mr. Elliott?
He needs to appear. If he doesn't appear, then I do what I gotta do.
And I haven't been with you enough to know better. Ma'am, it is not my fault you got knocked up 6 times and now have that many mouths to feed. Apparently your ex-husband has some stories. So here's what I'm going to do. I'm going to file an affidavit attesting to my evidence, and even if you try to keep me out of court, Judge Simpson will still have everything.
Elliott and Burrell. Are they here?
I'm here, Your Honor.
Elliott.
Why aren't they here?
I'm here, Your Honor.
Ms. Burrell was dismissed.
Oh, this happened like yesterday, 3 days ago.
Your Honor, if I may.
Go ahead.
I have evidence. I didn't know whether I was still allowed to appear in person as a result of the notice to have me dismissed. My partner is not able to get off work, but I have evidence for the court in defense of my partner.
Ma'am, I see now the notice of dismissal. You've been dismissed from the case. He's not here. He needs to be here.
Uh-oh.
Understood. I've been messaging with my partner to see if they can do something to make it. On the meantime, I do have evidence that I have been given that I can put forward.
He needs to be here.
He going to jail.
If not, I'm going to default him because he needs to be here.
Understood.
Come on, Mr.
When is he going to get here?
I don't know. Again, my partner is in the middle of work, doing everything that can be done to be present.
Well, it's to be fair to each side. I give him 20 minutes. He's got to be here. If not, I'm defaulting him. Will that work for you, Mr. Lloyd?
20 minutes it is, Your Honor.
All right.
10:15 our time.
Uh-oh. It's over. It's over.
Okay.
Entitlement is over.
Lepic versus Andrew Elliott.
Yes, here.
I bet your ass
That's
popped
Mr.
up now.
Lepic, right?
Yes.
Your Honor, on behalf of
Andrew Elliott. No response. Would you like to take a default? I gave you. All right, raise your right hand. Do you solemnly swear affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, your claims.
Your Honor, there is already right now the amount of $15,000. There is back to water bill that hasn't been paid, amount of $584.
Wow.
There is a question, Your Honor, about late payment charges, and if you want to address those, the court had commented on in the last hearing, and because of the amount.
Yes.
It's crazy.
They were rather large.
Might I make a pitch?
Certainly.
Your Honor, what's going on in this case, I agree, as a purely landlord-tenant case, the amount of the late payment penalties is large. But in the context of the sale of the real property based out of earnest money and late performance of a purchase agreement, the amount is perfectly normal. I mean, I'm told that this was a $700,000 home being sold. Normally, you have 1% or 2% of earnest money. And so, in terms of a good faith attempt for the parties to establish a number that could reflect the consequences of the default, I think the late payment charge is large, but not unconscionable. I don't know what the standard code is.
I think it is. Well, I would say that the late fees are unconscionable, and also the late fees can't be liquidated damages. In the scenario you put up, they could be in a certain respect. In this instance, the late fees have to be related to the landlord's ability to collect rent. in some reasonable amount.
Yeah.
So I would not allow them. If you want a hearing on that, you show it to me, then.
I see it a different way. In the context, I think I am less shocked because I see 2% would be a typical earnest money deposit. This is less than that. But in the context of monthly rent payments, I'm not going to make that argument.
15.
Your Honor, there is now we have an not earnest money, a security deposit that I want to be applied. I've got damages of $15,584.
Damn.
We'd like to apply the security deposit of $8,550, and what we'd like is a judgment $7,034. I don't have my costs.
7,000.
034.60. Now that's the net judgment.
After application of the
After application, and I have a judgment for the.
So here's what I would do. I would take your total, make it clear under the further orders provision that the court is permitting this security deposit to be deducted since they vacated the premises, so that the full judgment is actually the full amount, and then the security deposit being deducted, so that we don't have. Because I think there's going to be a problem if we do it the other way.
I have prepared a form. If you can see, let me fill it out. I'll prepare it. I'll offer to the court. And look at it right.
All right. And your court cost in this case, I have 130. I don't.
Process serving bill, and we got 75.
I have the process serving. I have a 0 service fee on both. I have no service fee. Okay.
So that would give us 205, I believe.
Yes, 205.
I will present more.
All right. Thank you.
Yo, you have to have been through a situation like that to really understand a situation like that. There are scammy landlords, you know what I'm saying? I went through a situation where, we had got, we wanted to get a private owner. I live in Vegas and, was trying to get an apartment, a condo out here. And, we met the people. It was like an older lady, he's a dude. Everything was cool, you know what I'm saying? And I'll say about 3-4 months in, we got a knock on the door by the actual owner. Embarrassing as hell. So stories like this connected me, man. If you got stories like this, let me know in the comments. Also, we need subscribers. Feel free to subscribe, hit that top bell, and I'll see you on the next one. I'm out of here.